I'm Osler McCarthy, and I'm talking with Chief Justice Joe Greenhill, reminiscing about his time on the court, extensive in Texas jurisprudence. Today is Tuesday, December the 12th, 2006. Chief, I want to talk with you first on a remarkable career. You were uniquely a law clerk in two different times, before and after World War II, and then later were appointed to the court 11 years after your law clerk duty. Talk with me about the early court and your law clerk experience.
When I was offered a place on for the briefing attorney, it was a highly desirable place, and it actually paid more than most young lawyers made. And the people that I clerked with were just extraordinary briefing attorneys. There was Clarence Guittard, who was later Chief Justice of the Dallas Court of Civil Appeals, Harry Shuford, who was my brother-in-law. He was president of the Federal Reserve Bank in St. Louis, and several others that were Phillips, who was later Chief Justice of the Austin Court of Civil Appeals. At that time, the Supreme Court of Texas started mainly with a three-judge court, and they began to get behind, so there was created a Commission of Appeals, which were 6 very able lawyers, and they were not elected, they were appointed on qualifications alone. And they helped the court a great deal on opinion work, petitions for writ of error, which are now petitions for review, motions, mandamuses. It was just one problem: they couldn't vote. And quite often the 3 judges of the Supreme Court and the 6 members of the Commission of Appeals, which included J.E. Hickman, who was Chief Justice when I was sworn in. They were very bright lawyers, and there was several problems which were subject to differences of opinion between men of goodwill and good thinking. And on 3 or 4 really vital issues, the court and the commissioners simply disagreed. All 6 commissioners would have voted the other way if they'd had a vote. I was there when there was a 3-judge court. I briefed for the court rather than a judge or judges, but I mostly worked for Judge Alexander, Chief, and Judge John Sharp. The third one that I was supposed to help was Richard Kreitz, who was a wonderful guy, but he didn't want any boy telling him what the law was. And in effect, he told me to stay the hell out of his office. So I got to work for some of the commissioners, as well as Sharp and Alexander. During World War II, I was out at an area around Guam. The Constitution of Texas was amended to make all 6 commissioners judges of the court, which meant they had a vote. And on most things they agreed, but on several particular issues, the 6 who had been commissioners without vote now became the majority. This was particularly true with regard to appeals from boards and bureaus, including the Railroad Commission. When the board or commission made a ruling, granted or denied whatever relief permit was asked for, the loser wanted to appeal. And this brought in an appeal to the district court. Chief Justice Alexander strongly believed in the constitutional right of trial by jury. His view, which was the court's view, was an appeal from the Railroad Commission, Banking Board, or whatever. When they got to the courthouse, you started all over with a trial by jury. The Commission of Appeals, particularly Judge Slatton and Judge Hickman, thought that there was a rule in other jurisdictions called a substantial evidence rule, which was that if there was substantial evidence to support the conclusion of the board or bureau, say the Railroad Commission, it would be affirmed. And the question was not a new trial by jury, but a question of whether there was substantial evidence to support the action of the board or the commission. Well, the Alexander rule of the 3-judge court of a complete trial de novo and the substantial evidence rule clashed, and the opinions of the court were overruled, and this greatly displeased Judge Alexander. Who's to say who was right or wrong? The reasoning of the commission was that cases should be tried and appealed promptly, and there were thousands of orders of boards and bureaus, and if you tried a jury trial in every one of those, the court would get more badly bogged down. It was already bogged down, and the substantial evidence rule allowed actions of boards and bureaus and the Railroad Commission to be finalized relatively promptly.
In your unique experience, having served the court twice as a law clerk before and after the war, once with a 3-judge court, and then you came back to a 9-member court, and you're talking about that shift in jurisprudence, the commission view on substantial evidence wins out. What else did you see in that change, remarkable change? The court triples in size.
There is presently a rule of products liability if it's a tort, where there's something wrong with a product. In the early days, that sort of action was not a tort, it was a contractual action with there being an implied warranty of fitness of the product in the sale. And if there was a bad product, you sued the guy that made it. With our current economy, a whole lot of things are made in a distant state or even in a different country, like Australian beef. And the question was, how do you try those cases? Well, in this particular area, Judge Alexander was he was a liberal. He would allow the customer to sue the seller. The cases before the court involved defective canned goods, beans, spinach. And we didn't know about E. coli, but I guess that was it. Anyway, the corner grocer that sold the product hadn't been negligent at all. He received the can from a wholesaler who got it from an importer who got it from a producer. And if you sue the corner grocer, he would say, look, I didn't do anything wrong. I didn't allow that to sit out in the sun and get bad. But Alexander would still allow the suit against the corner grocer. Well, the commissioners didn't like that, but that became the rule. And as I said, it eventually developed into what we now know as products liability, which is a tort, not a contract.
And you've mentioned I don't know whether it was the growth of the court incorporating the commissioners, but contributory negligence in your time became comparative negligence. Talk about that.
The earliest Supreme Court, when I went on it, was a great court, great people. But they followed the common law of England. And I think they thought it was their duty to follow the common law. Their oath was to support the law. But the common law of England, in my opinion, was weighted in favor of the manufacturer, the property owner, and the person who was injured had a tall hill to climb, so that if there was even 1% contributory negligence, the plaintiff lost. Even though the other side was 99% at fault. And as far as workers were concerned, the employer was protected because the laborer was deemed to have assumed the risk of being injured. Well, if you have to work, dangerous work, and you assume the risk. At least I thought the balance of justice was tilted in favor against the plaintiff. So our court, not just my action, but the court came to this view, and it abolished the contributory negligence concept. When I went on the court, if the worker should have known and should have appreciated the risk, he lost or she lost. I wrote an opinion called Halapeshka against somebody, and we changed the rule to where the plaintiff must actually know and actually appreciate the danger. That limited assumed risk a good deal, but we still had it. And later, Judge Stakely wrote an opinion just completely abolishing assumed risk, and I thought that was a fair decision, and I voted to overrule my Halapeshka decision, which upheld assumed risk. So the court, with the help of the legislature, came to comparative negligence, which I think is fair. At least it's a whole lot more fair than totally losing if you were contributory negligent at all or assumed a risk.
I want to go back to the early court, and I believe this was when you were law clerking, but Judge Alexander took over a great backlog from the Curtin court, and you mentioned to me about how in dealing with it, he insisted on an opinion being written before oral argument.
Well, this was up to the individual judge. Alexander had me write, or some other law clerk, write an opinion 2 weeks before the case was to be argued orally. This would have been a great shock to the lawyers, but they didn't know about it. And Alexander didn't use that opinion, but he circulated it, perhaps. And if anybody disagreed with it, now's the time to say so. And then the case would be argued orally, and the opinion would be tested by the oral argument. Then Alexander wrote his own opinion. Judge Sharp and most of the rest either wrote their own opinions or asked for a draft within, say, 2 weeks after the oral argument. And we prepared all of the preliminary work on applications for writ of error of mandamuses. One thing that might be interesting, the court didn't have any recording devices. And when I was chief, it got to be an emergency where we had to have, I wrote an opinion stating that counsel had agreed on oral argument that the motion for a hearing says we didn't agree to that at all, and we didn't say that in the oral argument. Well, I had heard it, and the other 8 judges had heard it, so the motion was overruled, but I said, we just got to have some recording equipment. We're naked if we say we heard something at the oral argument and counsel said he didn't say it. This is indefensible, so the law clerks actually made the first equipment, the recording equipment. We didn't have any appropriations for it. They made some very usable but primitive recording equipment. And if the present court listens to this, I would say to them they need some amplifiers, they need some speakers. I attend oral arguments from time to time. I have relatively good hearing, but I can't hear their questions from the bench.
When you, going back again, this law clerk experience, then in 1957 you're appointed to the court. On your appointment, you're a Price Daniel man because you served for him in the Attorney General's office as first assistant. talk about the politics of that and how it played out.
Well, people don't know judges, and lawyers don't know very much about judges, and they make assumptions about the outlook of the judge. When a judge is appointed by what they regard as a conservative governor, they assume that the judge is of the same view. If a judge is appointed by a liberal governor, they assume the judge will be liberal. Well, because Price Daniel had been opposed by Ralph Yarborough, who in my opinion was a very fine man, but the politics were that the labor unions and the left would support one candidate and the insurance companies and the right would support the other. Well, Yarborough had run against Alan Shivers, and there was a distinct left and right. Since Yarborough was the opponent of Daniel, there was the same view of left and right, except that Price was not a real good liberal, and he was not real popular with the far right, and it was a very close campaign. When Price appointed me, I acquired his friends and his enemies. And right after I got on the bench, a very fine woman judge, Sarah T. Hughes, announced against me, nothing personal, she just wanted to be a judge, Supreme Court judge, and that's admirable. But she likewise inherited Yarborough's friends and enemies, and I got his Price's friends and his enemies, whether they fit or not. So when I ran, the labor unions were very strongly against me, and insurance defense just assumed that I was a good judge from that point of view. Well, I guess I disappointed both of them. I tried to get the case right, whether it was left or right. When I ran for chief, it was the far right that tried to get me an opponent. I didn't have one. I didn't have an opponent for either 23 or 24 years, Democrat or Republican. People try to get you an opponent or run against you for a judgeship if they're afraid of you. If left or right thinks they're not going to get a fair shake, they'll get an opponent for you. And without realizing it, I think trying to decide cases down the middle is the best politics. The only way you could survive for 25 years.
That raises a question. You talked about inheriting Governor Daniels' friends as well as enemies, and the assumption that because he appointed you, then you were going to reflect him. How did you develop, and what is a judicial philosophy?
I'm ashamed to say I don't know that I have one, except to get decide the case right. You have to use precedents, and sometimes I wrote opinions that I really didn't like, but, well, there's a difference between contract actions and tort actions. In contract actions, people conduct themselves and their business rightly relying on what the law is. They make big contracts relying on what the law is. And even if you don't like the law of contract should be tampered with, in my opinion, very carefully. Maybe that's a judicial philosophy. In tort law, people don't have an accident or assault somebody with any reliance on what the law is. They just do it or have it done to them. And the tort law can be changed and should be changed to reach a correct result. Even that sometimes is circumscribed by legislation. The legislature tells us what the tort law is. But if the judge is free to choose, overruling a tort common law is more justified, in my opinion, than fooling with the contract law.
Have the laws considerably in tort changed? It's more statutory than common law anymore. Is that a good change or a bad change?
I don't know. There's a danger of the legislature encroaching on the judicial branch. There's supposed to be 3 equal branches, but some are more equal than others. And particularly as to appropriations, the third branch is a very poor relative. And the legislature enacts tort law as a result of pressure from one group or the other. And I would hope they would largely leave that to the courts to decide.
When we talked about your own jurisprudence, one of the decisions you pointed to proudly was the Railroad Commission versus the City of Austin. Take me through that.
That was a very important decision, and either led to the South Texas nuclear plant as a source of energy. At least it got the City of Austin into it. The price of gas has gone up and down. Natural gas has gone up very remarkably from real cheap to real expensive. In the early days, before I got on the court I guess it was in the 1920s, City of Dallas had a contract with Lone Star Gas for natural gas for the City of Austin, which in time of winter was used by people for heating their homes. The contract with Dallas for its gas ran out during the dead of winter, and the price that the City of Dallas was going to pay for gas from Lone Star was negotiable. They couldn't agree on a price, so Lone Star just cut off the City of Dallas gas supply, and it caused some very bad suffering. So Governor Hobby called a special session of the legislature to remedy the problem, and there was enacted a statute called the Cox Act. It permitted the Railroad Commission to fix a price if the parties couldn't agree on one at the city gates, and so the Dallas situation was solved. A price was either fixed or agreed on. Cox Act also gave the Railroad Commission very great powers. Later on, the city of Austin and San Antonio had a contract for gas at, say, 30 cents a thousand cubic feet. You could then go out and buy gas for half that, and an enterprising fellow from South Texas went out and acquired a large gas supply, and San Antonio and Austin signed up with him at, say, 15 cents a thousand cubic feet. They didn't think about the necessity for guaranteed reserves. Well, this same fellow had a reserves in West Texas, and the price of gas went up again, and he saw the opportunity to make a profit. So he sold all of the reserves of natural gas, which had been allocated or should have been allocated to Austin, San Antonio. He sold them to the Dallas utility, and then in the dead of winter, the Arabs had cornered the market, and there just wasn't any gas for sale. And Austin was about to brown out. They were bringing in oil in trucks and converting it to natural gas. So an action was brought, this action, Austin against the Railroad Commission, to make this person who owned the reserve gas, natural gas, to annul the contract whereby he sold it to Dallas. And that was the question. Did the Cox Act enable the Railroad Commission to nullify a contract so Austin would have some reserves? It came to our court, and I drew it for writing. There was $1 million worth of lawyers on both sides, but they didn't satisfy the court or me on the answer. I had 2 law clerks, good ones, and I sent them to the libraries, University of Texas and the state libraries, for the history of the Cox Act, what it was meant to do. They found a beautifully written thesis written at the University of Texas for a PhD degree, and the research was all done. Problem was the University of Texas had not approved the PhD. They didn't approve the thesis for some reason or other, so we couldn't use it. But we used all the footnotes, and in that opinion, we rewrote that PhD thesis. And the answer was the legislature intended to give the Railroad Commission broad powers, but not the judicial power to annul a contract. That's a judicial function. So the city of Austin didn't get its gas, and I was regarded as a no-good judge. I was very unpopular in Austin. And for the Austin to get the supply they needed of energy, they joined the South Texas Nuclear. Now I guess we get both.
I don't know whether you coined the phrase, but the phrase is that there are lawmen and equity boys.
That was Calvert's.
Calvert's?
Calvert. That
That's
was
right. That's
Chief
right.
Justice Calvert's division of judges into lawmen and equity boys, and he put me with the equity boys. I didn't like that, but you didn't argue with Calvert. Calvert was a very strict constructionist, and the devil take the hindmost as far as he was concerned. He just followed the law, and to hell with what anybody thinks.
Now you succeeded, Calvert. And how did the court change with you as chief for 10 years?
I don't think it changed very much. I admired Calvert, and Calvert's idea and mine was both of us were, our duty was to get the right decision. He was probably a more strict constructionist than I was in tort law and some of the old common law. I would have changed that where we could.
So the court really didn't take a dramatic direction change.
I learned something way back when I was a law clerk. As you know from observing the present Supreme Court in action, when a case, well, it's different in that the present court communicates by email or whatever. We didn't have any of that, and our Tuesdays were to discuss opinions. A good Chief Justice would sit at the head of the table and start asking for opinions and views either to his left or his right. And I did that, and when it finally came back to my place, there were generally always 5 votes one way or another, and so it didn't make any difference what I thought. A Chief Justice is not effective if he or she says, this is what we're going to do. This is my court, and this is the way we're going to run it. That just won't work with separately elected 8 other justices. You don't tell them what to do, not even the chief. And if you try, you go come out second best. And some of that happened after I left the court.
Now, you mentioned to me before that you were instrumental after the Constitutional Convention of 1974. The idea of creating a unified court system for Texas, all that failed, but you picked up and in the end got the amendment passed that gave criminal jurisdiction to a woefully behind, or to the Court of what then were civil appeals.
I inherited the job. As far as I'm concerned, the one that first started it when I was conscious of it was St. John Garwood. He wanted a unified court and a selection of judges by what was then called the Missouri Plan. That is, a governor would appoint a judge. He had a committee who would give him 3 to 10 names, qualified people, and he must appoint one of those, not as campaign manager as Daniel appointed me. And then he or she served for a while, and then the question is, should that judge be retained or not? people don't know how to elect a good judge because they don't know the judges. But they know a bad judge, and they have the opportunity to remove him or her. St. John Garwood called this judicial Planned Parenthood. Calvert took it up, and he worked very hard for a unified judiciary and a proper selection formula for selecting judges. The whole Constitution of Texas came up for adoption or not, and the judiciary article provided for a unified court system. That is, the Supreme Court of Texas and the Court of Criminal Appeals would be merged. Some hard-nosed people just said what we ought to do is abolish the Court of Criminal Appeals, give the Supreme Court of Texas criminal jurisdiction. Well, my view was to merge the two courts, not put the Court of Criminal Appeals down, but just merge it. It ought to be one Supreme Court, civil and criminal, and the appeals court ought to be civil and criminal. Well, the whole Constitution failed, not on the judicial part, but there was a proposal for the legislature to meet every year. The tax laws were changed. Many other laws were changed. And that the whole Constitution failed. Well, when I came in, I knew I couldn't get the whole Constitution redone, or even the whole judicial article, but there was every reason for the courts of appeals to have civil and criminal jurisdiction. At that time, every criminal conviction went directly from the district court to the Court of Criminal Appeals, thousands of them. And that court struggled mightily, but they were still very far behind, 4 to 6 years. And this was inexcusable. So I proposed that the courts of civil appeals be given criminal jurisdiction. At that time, we had a Republican governor, Bill Clements, and he agreed with me that was a good idea. I was not a Republican. I'm an independent. I vote. The present Supreme Court is all Republicans, and I support them. But at that time, he was a Republican and I was a Democrat, and we held a joint press conference to kick this thing off. And there was no organized opposition. I learned that when you debate a constitutional amendment, wherever you debate, if it's on radio or TV or at the Rotary Club, the thing to do is to give equal time to both sides. And the affirmative in a constitutional amendment has got a terrible burden. You can speak 15 minutes why this is a good idea, and 15 minutes for your opponent, and they can think of 15 to 30 reasons why it's a bad idea. If any one of the negative appeals to the voter, they'll vote against it. So I thought the thing to do was to refuse to debate the constitutional amendment, and I did. And I opposed speakers' bureaus to speak for or against it because they would kill it. The legislature, which which allowed this constitutional amendment to go to the people. When you get to the ballot, the people are presumed to know what they're voting on, whether they do or not. And there's a cue to what you're voting on. Like in this instance, the legislature said a constitutional amendment to speed the affirmance of criminal trials or something like that. Well, that's a good idea, and the constitutional amendment passed very readily. And there was, with the cutting off of debate, no organized opposition developed. In that same amendment, we codified the inherent power of the Supreme Court. There was a debate as to whether the court had any inherent power or not, and to what extent, and that is spelled out in the Constitutional Amendment.
The short term, the big problem was to solve this criminal backlog with direct appeals to the Texas Court of Criminal Appeals. But wasn't the inherent power in some ways more far-reaching?
They're both far-reaching. I think it was really more important to give finality. If a person had been wrongly convicted, it ought not take 4 to 6 years to get that reversed. On the other hand, if he's rightly convicted, he ought to start serving his or her prison sentence.
Chief, I'm sorry.
The inherent power of the Supreme Court was greatly useful to the Bar Association and things of that nature.
Speaking of which, you were instrumental in building the building that we're in right now.
Yeah, this is the Texas Bar Association understandably felt like it ought to run its own business, and the Supreme Court should stay out of their business. Well, they had a real nice fellow named H.C. Pittman, who was executive director of the bar, and he and the bar's board decided to build this building. It was an $8 million project, and the source for the money was mainly from donations or gifts from lawyers, which they wrote off on their income tax as a professional expense. Well, when that $4 million of the $8 million had been raised, the Internal Revenue Service decided that this would not be tax deductible for lawyers. Well, the bar thought about a second campaign and had Leon Jaworski to head it up. But the taking away of the income tax credit for gifts to the bar just killed it. And with that, the bar came to us and said, well, after all, the state bar is an arm of the judiciary, part of the judicial branch. Help us. How can we help? Well, since we can't get donations from lawyers, we can raise the bar dues. So we did at on the inherent power of the court that the bar was an arm of the judiciary. Well, that pleased the bar, but lawyers are greatly independent. And they said to the Supreme Court, you can't do that. And we just said, well, you watch. And we did it. And I got sued several times in the state, me in the Supreme Court, but my name was in the title of the case because I was chief. And mostly in the federal court, we had a problem, but the federal court said that this was all right. And so we raised the bar dues enough to pay the second $4 million. I don't guess the bar dues ever went down. I don't know, but we did get it paid for. Now the Constitution, under this amendment that you mentioned, makes the bar an arm of the judiciary, so that if this problem comes again, and it did come again, the legislature created a state bar. And they have, if they create, they can uncreate. When they uncreate, it's called sunset. They just let that law go down like the sun. And the question was whether the legislature got mad at the state bar and wanted to sunset the bar. The court met, and we created the state bar of Texas under our inherent power, and then went to the legislature and said, now you go ahead and sunset it if you want, because we've created a better state bar. And we thought we had. Well, they didn't sunset the state bar, so I think there's two grounds for the creation of the state bar now, the legislative, and they kept whatever control they wanted, and the judicial, the creation by the Supreme Court.
I want to ask you, what, if you look back over your long career in the bar, on the court, what's the remarkable turning point that you would point to and say, this is where my life changed?
Well, I guess when I went on the court, my wife was not really enthusiastic about it at all. The reason was economic. I was a partner with Austin law firm, was Graves Doherty in Greenhill at that time. We'd been partners for about 7 years, and we'd gotten up to where we were making $50,000 to $60,000, $1957, which was pretty good. When I was offered a place on the Supreme Court of Texas, it paid 20. So I went from 50 to 20. You've got to like something pretty good to take that kind of pay cut. My wife is a wonderful wife, and we had 2 boys put to the University of Texas, and this cut her income a good deal. But it was a major step, and that's what I wanted. Same was true after 25 years. After a while, the Bible says there's a time for everything, and time to quit is one of them. And Baker Botts, which didn't offer me a job when I graduated, did offer me a job to help open the Austin office of Baker Botts. And this time they had a very substantial increase in pay, more than the chief paid, and there was no argument at home about taking that. That was major.
And you're still going to work.
I'd rather work than not work. My wife was very kind. She said she could say that she married me for better or worse, but not for lunch. And I enjoy work. I'd rather work than not work.
I want to ask you about one last thing. As Chief Justice, you have a place out in the state cemetery, you mentioned, and you're going to be at the foot of...
Very early in the Supreme Court, after San Jacinto, the only statewide Supreme Court member was the Chief Justice. And the associate justices were the judges of the district courts. There were about eight or nine district courts. So the district judges sat for a while as district judges, then they would be associate justices of the Supreme Court. And one of them was a fellow named Williamson. Georgetown is in Williamson County, named after him. He'd had a disease as a child, like polio, which withered one leg. Instead of cutting that leg off, they strapped it up with a leather brace at the knee behind him and gave him a peg leg. So he had one good leg, one peg leg, and one leg strapped behind him, and they called him Three-Legged Willie. He was a good judge, and he has a monument at the state cemetery. When I was on the court, I was assigned a place for Martha and me to be buried, and my place in history will be that I'm buried at the foot of Three-Legged Willie. I don't know which foot, but I will be buried next to Three-Legged Willie.
Chief, enjoyed it, appreciate it. There's not too much chance in 55 minutes to capture many memories you could talk about, but appreciate you.
Well, you've done very well. I don't know how you'd handle me or get me to talking, but I think it worked out pretty well.